you've ever had the disastrous case of trying to naturalize somebody, and USCIS can come back and say, despite them being a green card holder, we don't believe they've been lawfully admitted for permanent residence such that they can naturalize. Maybe they find that they didn't disclose a criminal arrest in their green card application, or that USCIS made a mistake. They can come back and essentially, as you know, do full-on LPR adjustment inquiries at the naturalization stage. And not only might they deny naturalization forever, right? Because you're never going to then fix your unlawful in their terms entry, but like they could file notice to appear, try to remove you. Now, a lot of that comes down to USCIS's own regulation. It's 8 CFR section 316.2b. The statute itself just requires, and I want to do the quote, that the non-citizen who's applying to naturalize have been, quote, lawfully admitted for permanent residence, end quote. And that term is defined in INA section 101A20. So USCIS, in requiring something more than just having LPR status to naturalize for 5 years, has added a requirement not contained in the INA. That not only you have LPR status, but like that LPR status was completely correct and there's nothing possibly wrong and you have to meet substantive requirements. That's the argument. Been making that argument for a long time. A lot of people have who get caught with this, and well, Ben just kind of won it. Mr. Azumah, it's a bit sui generis of a case. Mr. Azumah had LPR status. I think he got some conviction, which they believed was a CIMT, left the United States. And because of that, when he tried to come back in, DHS charged him as an applicant for admission and put him in removal proceedings. Very dangerous, because now he's not even being treated as a LPR. He's being treated as an applicant for admission. But then, with the agreement of ICE, those removal proceedings were terminated. Prosecutorial discretion, who knows, whatever. Removal proceedings are terminated. And so he applies to naturalize. Still an LPR, right? Has had it for more than 5 years, all those requirements. USCIS got real cute, though, and said, no, because you are still being treated as an applicant for admission. We're not treating you as an LPR because, you know, you were an applicant for admission and that was never resolved. Like the proceedings were simply terminated. Your last entry was not as an LPR. It was as an applicant for admission, is what USCIS said. It's not crazy. It's just a very unique fact pattern. But the Fourth Circuit says, no way. Like, the regulation, again, USCIS regulation requires, quote, that the applicant was lawfully admitted as a permanent resident of the United States in accordance with the immigration laws in effect at the time of the applicant's initial entry or subsequent entry. All of that is more than what the statute requires. The Fourth Circuit held, quote, lawfully admitted as a permanent resident for naturalization is simply clearly intended to reference the substantive requirement of LPR status found in Congress's naturalization statutes, end quote. Nothing more. To naturalize, you need to be an LPR. You just, and not have lost it. At least in this context.